Okay, so tonight I'm going to start off with the civil portion. I'm going to be talking about motions for summary judgment and motions for summary adjudication. So if you have your outline, you guys can follow along with this. If not, it's okay, no problem. Okay, so basically a motion for summary judgment, MSJ, motion for summary adjudication, MSA, is basically where you can bring a motion and win before going to trial, right? Does that make sense? You're asking the court to rule, make a ruling, and say that there are no triable issues of fact here. So, and that because of that, you're entitled to a judgment as a matter of law. Now, the controlling CCP section for this is 437C. So that lays out all of the requirements for an MSJ and an MSA. So I've laid out in two different boxes here on the outline the difference between an MSJ and an MSA. So an MSJ is basically asking the court to determine an entire action, whether the entire action has any merit to the case. Basically meaning there's no defense to the entire action. So if a court grants an MSJ, the entire action is then terminated. There is an immediately appealable judgment that is entered. So for an MSA, you're asking the court to adjudicate the merits of a particular cause of action, an affirmative defense, issue of duty or claim for damages, punitive damages. It's like a portion of your case versus the entire case. So what happens is the court will grant on a specific portion of the case. So whatever is asked in the MSA, it will be granted on that specific cause of action or punitive damages or issue of duty. So the other thing is that this ruling is not appealable. So in MSJ, the ruling is for the entire case and it is immediately appealable, and MSA is not. Okay, so the burden of proof on the motion, let's see, parties moving for and opposing carry both a burden of persuasion and a burden of production of evidence. So a burden of persuasion is that there's no triable issue of material fact and that you're entitled to judgment as a matter of law. That's the burden of persuasion. So the plaintiffs moving for summary judgment bear the burden of persuasion that each element of the cause of action has been proved and that no defense exists. Okay, so next we have okay, so for a defendant moving for summary judgment, you're bearing the burden that one or more of the elements or of the cause of action cannot be established, or that there is a complete defense to this. So keep those burdens in mind. The burden of production, let's go over that. So the moving party bears the initial burden of production to make a prima facie case that there are no triable issues of material fact. So if the moving party carries this burden, it causes a shift, and the opposing party is then subject to its own burden of production to make a prima facie showing that a triable issue of material fact exists. Okay, so these are the burdens. I've gone over that and gone over what it is. So let's go over the practical stuff. An MSJ can be costly. The filing fees are around $400 to $500. So you have to think about that. And also, you have to think about the time that it takes to prepare an MSJ, MSA. It's burdensome, it's onerous. It takes a lot of time to prepare the motion, go through each cause of action, all of your evidence, all of your deposition transcripts, all of that. It takes a lot of time and effort to bring the motion. You'll get an opposition back, and then you'll have to do a reply. So for both parties, it takes a lot of time and effort. And there's a lot of special formatting. We'll go over that for the separate statement. And that takes a lot of effort So you just have to keep that in mind and make sure if you're going to bring one that you know what's at stake here as well. So the other thing too is it can be used to see what the opposing counsel is going to be bringing in terms of its evidence. What defenses are they going to be bringing to the table? What sort of is their game plan per se? You kind of get a sneak peek at that as well. So those are some things to think about in bringing an MSJ and MSA. And also the other thing too is you can bring an MSJ alone, but most of the time you want to bring an MSJ or in the alternative an MSA. That's how you would title your whole motion. Are there any questions so far? Good. Okay. We'll move on here.
Yeah, if you have a, let's say, 10 causes of action.
Excuse me?
If you have a case with 10 causes of action.
Yes.
Number one, but all of them come back to number one, and if you disprove number one, all the rest will just automatically fall. Do you go for an MSJ for that, or just an MSA for that one?
I would bring an MSJ for all the causes of action, and you can refer to the same evidence, basically. And then you would entitle it the same MSJ or in the alternative MSA. And then to cover all of your bases. Yeah, that's what I would probably do. Okay, so let's go on through to the procedural requirements. What's required, it's like a normal motion. You have a notice of motion, points and authorities, you have a request for judicial notice if appropriate, and declaration of all the evidence, right? All of the testimony, maybe if there are witnesses, etc. The only thing that is different about an MSJ, MSA is that it requires a separate statement of undisputed material facts. And we'll go over that. It's a very specific format. Yeah. Yeah. So that's something to think about too. Okay. Let's see. So in my outline, I've outlined like when the motion may be made. So I'll just go through that really quickly, and then you can review it on your own time. So it's a 60-day hold at the beginning of the case. You can't bring an MSJ or an MSA until at least 60 days after the general appearance of the party against whom it is directed, unless the court permits it earlier for good cause. Okay, so keep that in mind. There's also a 30-day cutoff before trial, so you can't bring a motion less than 30 days before trial, unless the trial is continued for good cause, right? Then you can bring your motion. Service and filing requirements. It's a 75-day notice requirement, which is a very long notice requirement, and depending on whether you serve it, let's see here, by mail or internationally or e-service, it can extend the service time, the notice time significantly. And also keep in mind if your motions are heard in a certain department on a certain day, that can add more time to your motion as well. So keep those things in mind, and because if it's beyond those days, you're not going to be able to bring your motion. So the notice of motion should, let's see here, summary judgment, it should have the name of the party in whose favor and against whom the judgment is sought and the amount, if applicable. If it is a multi-party action, meaning if you have many defendants or many plaintiffs, directing it to all opposing parties is not adequate notice. You actually have to, or where there's different relief sought for each party, so you should direct it to that specific party in the action. Summary adjudication, let's see. The notice must specify the specific cause of action, the specific affirmative defense or claim that you are requesting relief from. So just keep those things in mind. Now let's go over the separate statement of undisputed material facts. Let's see, I have provided a sample here, so if you guys can turn to that, it's the one entitled Response to Patterson's Statement of Undisputed Facts.
Kimberlite.
Excuse me?
Kimberlite.
Kimberlite? Oh, I have Patterson. Did I give you guys? Oh yeah, Kimberlite. Right. So this is basically how, this is a response. So if you are doing the separate statement as the moving party, this column would be blank. So this is how you set up a separate statement. The purpose of a separate statement is basically for the efficiency and ease of the judge to go through your case, what you're requesting quickly and efficiently, and to know exactly which evidence you are citing in your motion. So this is how you set one up. Let's see here. At the top, it has to have, so it's 2 columns. On the top on the left, it says undisputed facts and supporting evidence. And then, let's see, let me go through here. Let's see. So then underneath it, you have numerical sequence, your material fact that is undisputed. And then it has the site to where this is coming from in the evidence.
That is allegedly undisputed according to the moving papers.
Right.
Right?
Right. So in the sample here that I've given you in the outline, we'll just go over that really quickly. So it says undisputed material facts and supporting evidence, and then underneath it would say 1, right, in numerical order. And then it says Plaintiff Smith orally agreed to sell and deliver to defendant Jones 10,000 widgets for $100,000. And then it cited Smith's declaration and where that evidence can be found. So once you send that as the moving party, you have, upon request, the party must give an electronic copy within 3 days. So that the reason for that is the opposing party will then go based off that electronic copy and fill in the right side second column here with their response. So this is how it's going to work, right? So you send this left side column to the opposing counsel. Opposing counsel will then fill out the right side column and give that back to you if you're the moving party. Okay, so let's go over what the opposing party, how they'll set up the separate statement. So theirs will say, opposing parties' responses and supporting evidence, or evidence in opposition, right, on this side. And then it'll go 1 by 1. So you're basically responding to, number 1, number 2, number 3. And, you have to think about this. So the judge just wants to go through and go, 1, what are they saying is undisputed? Okay, and this is where the evidence is. And now I'm the responding party, the opponent, and what does the opponent say? You can say it's undisputed. That's it. It's undisputed. That's right. You can find it in that evidence, and that's it. There is a contract that exists, and this is true. So, or you can dispute it, and you can say why you're disputing it, and where's the evidence to dispute that? To the contrary. Or you can also provide objections. We'll go through that later. But you can also object to it. So you can have many different answers to whichever fact that they're trying to say is undeniable, undisputed. Okay. Do you guys have any questions? Is that clear? Okay. So the opposing party has a right to a continuance if they can declare that additional discovery may be available out there. There has to be good cause for this. It must exist, there must be a reasonable, that it may exist is not enough. It has to be reasonable that this evidence exists out there.
Normally, they also have to show why they didn't get it before.
Right.
So that goes.
Right, and then you also have to keep in mind, you want to bring this after you've done all your depositions, you've had time to get all the discovery, because you don't want to have to get a continuance from the opposition, right? Because that could delay this process a little bit more. So you want to bring these papers after you think you've had enough time and you've gotten all of the discovery in your hands. Let's see here. Okay, the opposition must be served 14 days before the date set for the hearing, unless the court shortens the time for good cause. Let's see here. Let's go over the objections, right? So you can object in your opposition, and you can also object in your reply papers. So the moving party would bring column 1, bring the motion. The opponent would fill in column 2. You can object to it, and then the moving party has a chance to reply as well, and that can also have objections, just so you can see how this will progress. So let's go through the objections. The objections are going to be another document. So you can state your objections in 2 different formats. One format can be, paragraph by paragraph for point for point in paragraphs format. And then if you, and then the second format can be column style. So your objection would be in a 3rd column. So you would have another column for objections on this side. Is that right, Chuck? Yeah. Okay. So the other thing to think about is a proposed order. So in the objections, a proposed order is required. When you're moving papers, the original documents, you can put forth a proposed order, but it's not required. So in the proposed order, you would then, depending on which format you choose, is how you would set up your proposed order. So if you chose format 1 with paragraph by paragraph style, underneath the paragraph, you would have, I have it here in the outline, but I know some of you don't have it. It would look like this. So you'd have paragraph, paragraph, and then court's ruling on objection number 1, sustained and a line, overruled and a line, and then you would have at the bottom a line for the date and a line for the judge's signature. Okay, so if you do format number 2, it would just be in a 3rd column, and it would have sustained or overruled, and then also provide a line for the judge's date and signature there as well. Let's see. You guys have any questions? Okay. In the reply papers, you can respond to the opposing party's statement of additional disputed facts. No separate statement of evidence is needed in the reply paper. You are not allowed to bring in new evidence in the reply papers. The moving party has a right to file a reply to the opposition, but it may not exceed 10 pages. So keep that in mind. Also, a proposed order is generally included as well in your reply papers. Let's see. I think that's pretty much it. Oh, and then the service, you have to serve and file at least 5 days before the date of the hearing, regardless of how they're served. And that's pretty much it. Does anyone have any questions? You have anything to add, Jeff?
No.
Yeah.
Basics.
Okay.
Sounds fun.
Okay. So you can take a look here. I forgot. I've also included some objections here, so you can see how they're set up. It's pretty long here, but we go here. Objection number 1. So this is done in paragraph format number 1. So you have paragraph. You have the objection number 1, grounds for objection. Here's the evidence code that states this objection, and then it just continues like that. See, objection number 3, paragraph style. So if you were doing format 2, you would have columns, and the 3rd column would be the objection. Okay, great. Who's next?
I do have one.
Oh.
do,
No.
no,
Okay, this is yes, there are different ways and there are different types of
Yeah.
papers too. This
Yeah.
one, the column one, this is the response, so this is the opposition,
yeah,
but this is how you're supposed to do an opposition.
exactly. And then this one is
The objection.
the movie, yeah, the objections to so it would be the third column possibly?
No, so this is objections, and I was saying this is done in format number 1,
Oh,
which
okay.
is paragraph by paragraph.
Okay,
The other way you could do it is column style.
Got
Two
it.
different ways to do
And
it.
that way it would look more like the UMFs,
Right.
just in format.
So then in format 2, you would have it in the third column is the objection. So
that's
either
what I'm
of
saying.
these.
Yeah, so this would be the third, this would be stuff that would go into the third column?
Yes.
Yes, cool, I got
Yes.
it, okay.
So these are different things, but
Yeah.
if this was done in format 2, it would look more like this with column 3 as the objections.
Got it.
But this is done in format 1, which is the paragraph by paragraph. They're both acceptable. It's just however you choose it.
All right, so again, my name's Jeff Thayer, and I'm going to cover the other part of our civil portion tonight, which is expert discovery. And the reason I'm doing this in this portion of the 5-part program is that a lot of the action with expert discovery tends to happen later on as you progress through the case, getting up until the point where you're getting close to trial. And that's partly because the expert deadlines run backwards from trial instead of forwards from the filing date. In my cases, there are usually a couple instances where I may start engaging with my experts earlier on in the case, and those tend to be situations where I'm dealing with an expert that I haven't dealt with before, or I'm using an expert where his work is I know that it's going to take a while to do. An example of that is I deal a lot with pathologists in my cases, and those are medical experts who study disease. And pathologists who do a lot of litigation tend to get very busy. They take a lot of other cases, and they schedule a lot of conferences and papers for themselves. So if I'm dealing with one of those in one of my cases, I'm going to make sure I engage him early on in the case as opposed to later on when I get closer to trial. But for a lot of experts, and in a lot of my cases I do deal with experts that I've used before, I may not start thinking about them until I get closer to trial, say 120 days out, because expert discovery can be expensive. It costs a lot of money to retain experts. They tend to charge very high rates for reviewing materials and rendering opinions. And so when I get closer to trial and it's around the same point in time where I'm thinking about doing an MSJ or an MSA, at that point I've got a sense for where we are in the case, what the evidence is like, what experts are going to be necessary, and I can make an informed recommendation to my client about what they should do as far as experts go. So, for a lot of expert discovery, you're really not going to start doing a lot of things until you get closer and closer to trial, although you can certainly, depending on the expert in the situation, start working with them months in advance just to make sure that you're well prepared. And expert discovery begins per the statute, and this is all in Code of Civil Procedure section 2034, with a demand. Any party can make a demand for all of the other parties' experts. And normally, in most cases, all the parties will make demands because they're all interested in what experts the other parties have. But keep in mind, even if only one party makes a demand, and let's say you have 3 or 4 other parties that don't, that one demand still obligates all the other parties to participate in the expert disclosure from them. So, and I've laid out in my outline how you go about making a demand, when you can make it. Keep in mind, you can make it at any point between 10 days after the initial trial date is set to 70 days before the trial date, whichever occurs later. If you're really concerned about incurring expert costs, you're going to tend to wait until the 70th day out to make your demand, although you can certainly make it earlier. There are certain requirements about what has to be in the demand that's laid out in my outline. And so the demand's going to state the date when all the parties have to participate in the disclosure. And that date's going to be either 20 days after service of demand or 50 days before trial, whichever is later. So keep in mind, if you wait until the 70th day out from trial to make the demand, which is the last day, then the 20 days after, the 50 days before trial is going to be the same day. So that's kind of how that timing works out together if you wait up until the last day to initiate expert discovery. And what the demand does is it requires all the parties to participate in what the statute calls a mutual and simultaneous production for inspection and copying of all discoverable reports and writings of the experts that are employed by the parties. Keep in mind, this is a two-way street. So if you make the demand, even if the other side doesn't make a demand, you still have to participate in the disclosure. You have to produce your experts' materials as well as they have to. Keep in mind that you want to be very careful whenever you're communicating with your experts. And I think I mentioned this before in our first session a couple months ago. You want to be very careful about what you tell the experts, because whatever you tell them is potentially, and actually it's more than potentially, it's likely going to be discoverable at some point. And for that reason, I am, very careful about how I communicate with my experts. That's one of the reasons I prefer to work with experts I've worked with before and that I know have been through the rodeo a few times, so they're not surprising me with anything that comes up that you might have to, that happens with experts who haven't dealt with the litigation a lot before. Communications that I have in writing with experts tend to be very, very brief. For example, if I'm sending one of my experts a document, it'll be attached to an email, and it'll simply say, please see attached document per our conversation on such and such date. All other communications with experts should be oral, if possible. And, the expert will have to eventually, if they're deposed, disclose that they talked to you. But at that point, the worst that's going to happen is they're going to say, I talked to the attorney for 20 minutes on this date about the case. I talked to him about my opinions, and that's the same. Those are the same opinions he's going to tell the attorney who's deposing them. So, that way you're going to keep the other party from discovering anything that you don't want them to by keeping your conversations oral as much as possible and limiting what you put in writing. Now, if you're served with a demand or you serve another party with a demand, there is a possibility they can seek a protective order to try to limit or excuse some of the information from being exchanged. And that would be on grounds of unwarranted annoyance, embarrassment, oppression, or undue burden and expense. I don't tend to see a lot of those in the cases I do. You want to know what the other party's experts are going to say, and if you're thinking about making that kind of motion, you usually have to have a pretty good reason. For example, the other side's requesting 1,000 documents or something like that. But so it is possible you can seek a protective order, but normally after the demand's issued, all the parties are going to have to participate in the disclosure and disclose most, if not all, of their experts' files. Now, the disclosure of information can occur either at a meeting of the attorneys involved or by mailing the information on or before the date that's set for the exchange. Almost all of the time, that's going to take place by mailing instead of an actual physical meeting of the attorneys involved. And the statute is very specific about what information has to be exchanged. Name and address of each expert. Now, it's each expert that the party expects to offer at trial, whether it's live or by depo testimony. So these are testifying experts. If you've retained an expert solely as a consultant, or the other party, the other side has done that, then they don't have to list that expert in the disclosure. Keep in mind that if you've retained a consulting expert and they prepare a report, and that report is relied on by one of your testifying experts, that report's likely going to become discoverable because the testifying expert's relying on it for their opinion. Doesn't necessarily make the other stuff that your consulting expert has done discoverable, but just, that's something you want to keep in mind when you're dealing with multiple experts and you're having some talk to others, some are testifying, but others aren't testifying. You just want to be careful about what they're sharing with each other. And with the expert disclosure, the attorney is going to submit a declaration that lays out certain facts as to each of the experts, their qualifications, a general statement about the substance of what they're expected to testify about. The attorney is going to represent that the experts agreed to testify and is sufficiently familiar with the case that they can give a meaningful deposition. And they're going to provide the expert's fee for providing deposition testimony and for their consultation work. And the information that has to be disclosed along with the identity of each expert is all of the discoverable reports and writings made by that expert in the course of preparing his or her opinion, which usually ends up, if you've got experts who keep files on each of their cases, that usually ends up being most, if not all, of what's in their file. Now, if you're dealing with, let's say, for example, a medical expert, they may not always have all of the stuff they rely on in their file. For example, a lot of times I'll retain or I'll be deposing a medical expert who has certain case-specific materials in his file. Then he'll say, I'm relying on 8 or 10 medical articles that aren't in the file. I just have them sitting around on my bookshelf or on my computer. Whether or not you can get discovery of that information, usually if there aren't too many articles, it's not that big a deal. If there are a lot, the other side may squawk about producing all of them and say, go out and get copies yourself. But if they're eventually going to rely on them, they probably do have to produce them at some point. When I'm deposing an expert who's relying on a lot of articles or a lot of documents, usually you can pin them down to the very central ones they're relying on. It's usually not 100 or 200, but it typically ends up being 3 or 4, depending on the expert you're dealing with. So that's not always a big issue, even if they start off the deposition by saying, I've got all these articles I could rely on. So keep that in mind. With the consulting experts, again, any advisory report they give you is going to be a protected work product unless they give it to one of your testifying experts, and your testifying expert is going to use that. There's also so there's that initial disclosure about 50 days before trial, and then there's the right to supplement that disclosure. Within 20 days of that exchange, you can serve a supplemental list.
Jeff, I have a question.
Yeah.
Let's say this field that these experts are going to testify on is very minute. It's like a very special case of, cancer, and there's only a handful of experts. And your opposing counsel has
that actually does happen in some of my cases with where you've got very specific areas, and that can be a problem. I've done it too. To try to reserve or take an expert out before someone else does. An example, actually, I was talking about pathologists earlier, and an example is a pathologist, Dr. Rogley, he's considered one of the top pathologists for asbestos cases in the U.S., and there are situations where plaintiffs retain him first, and there are situations where I've retained him first to I either use him or just make sure someone else can't use him. There's not a whole lot you can do about that. I mean,
Just be aware of it.
yeah, I mean, be aware of it, and if you anticipate that issue coming up, even early on in trial, that's an example of someone where I would retain him earlier than later if I think that's going to be an issue. And, a lot of times it depends on which law firm on the other side I'm dealing with, because certain firms, you know from previous cases that they tend to do that more than others. But yeah, that is something important to keep in mind. I mean, in a lot of areas, a lot of areas of expertise are a little more broad than that. For example, if you're looking for a construction expert, there are probably a dime a dozen, or at least there may be really good ones, but there are other ones you can look at too. But yeah, I mean, there could be very narrow issues like that where you want to make sure, if you know that issue is going to be important to your case, that you have an idea of who you're going to use early on in the case. Yeah.
Apropos of that, can you talk briefly about the best resources for locating experts in various fields?
Yeah, I mean,
Depends on the field.
yeah, I mean, there are resources out there in print and on the web, but you don't really get a feel for how good they are or what they've done. But you have to do a little research to find out what they've done before. Try to track down trial transcripts and depot transcripts and things like that. The better. I've usually had more success just talking to other attorneys about who they've used for similar issues or similar cases, because they're going to.
There isn't a .com that's tried to specialize in.
Yeah,
this.
I mean, there are different listings out there, but by talking to a colleague about it, I'm going to get a firsthand account of his or her experience with the expert, and they might even share some material with me that I wouldn't be able to get otherwise. So I can see for myself how the expert reacted under pressure and what sort of opinions they rendered. If it's a completely different area that you've never looked at before for an expert, you might have to end up consulting one of the lists that are out there. But
If anybody knows a good neurologist, could you speak to me?
You can also ask an investigator too. They might know.
yeah, I mean,
Because
they
work on
deal.
different cases.
Yeah, depending on the cases, they deal
Yeah.
with experts sometimes too. So.
Or they may be able to ask around their other attorneys that they work for, an investigator as well.
So once the demand is made and the disclosure happens, keep in mind that this is happening, roughly 70 and 50 days before trial. So after that, things are going to happen very fast. You're going to have to decide once you get the disclosure from the other side which experts you want to depose, if any, once you figure that out, you want to get your depot notices out pretty quick. And usually with those, you want to include a list of the documents you want the expert to bring with them to the depot. You can always ask the expert at the depot, what documents are you relying on, what's in your file, and get them at that time. But it's a lot better if you have that list sent to the expert beforehand, so they're more prepared to address that. When you're deposing an expert, be very careful to pin down on the record that they're telling you all of the opinions that they expect to offer in trial. Now, I mean, it's always possible that the expert's going to say, well, I might be asked a hypothetical trial, and I don't know what it is yet. But but they should be able to tell you, at least in a general sense, if not more specifically, these are the the 4 opinions I'm offering in this case, and this is what I can say about them at this point in time. Make sure you ask if they've done all their work. Is there anything else they're anticipating doing after the deposition? If there is, then you want to reserve your right to redepose them and or exclude their testimony at trial if they're going to do some more work that you haven't been able to ask them about at the depot. Make sure you ask them what their assignment was, or what were you told to do in this case, or even if you weren't told to do something specifically, they should have some understanding of what their assignment was, particularly if they're experts who have testified several times before. Get a list of the depositions, the trial testimony that they've provided recently. A lot of experts, if they give testimony frequently, actually maintain copies of lists like that for themselves. Get a copy of their CV and attach it as an exhibit. Make sure you have all the documents from their file and you attach those as exhibits. You want to get all the information from them at the depot, if whether or not you've gotten it before, and just make sure you're clear on what information the expert got and what opinions they're going to provide at trial, so you know what to do with them at trial, and you know if you can impeach them or object to their testimony. And keep in mind that motions to enforce discovery related to expert depots can be heard until 10 days before trial. So if you think that's going to be an issue, make sure you get the experts to well, the experts have to be deposed within 15 days before trial. So like I was saying, things happen very fast. Just make sure that you're meeting all of your deadlines. And the last thing I had in my outline was about so-called impeachment experts. You can have experts who weren't disclosed earlier called later at trial to impeach opposing experts, although they're somewhat limited in what they can say. They can't contradict the other expert's opinion, but they can contradict the foundational facts that expert is relying on for their opinion. So just keep in mind you can use undisclosed experts in that instance, but they're limited in their ability to testify. It's pretty much all I wanted to cover on experts. Anyone have any questions in general about expert discovery or depots?
I have a question. Like, what's the best way to impeach or defend against an expert that seems to be really knowledgeable in the field?
That's where scheduling, gamesmanship comes into play, because I like to. I'm on the defense side most of the time, and I like to have my experts deposed as often as possible after the other side's experts, and after I get the reports from the other side's experts. That's not always possible with scheduling, but I like to try to do that as much as possible. So a lot of the impeachment doesn't necessarily come down to the questions you're asking the expert, although that's certainly helpful, but it comes down to what the opposing expert is going to say. As far as just taking a deposition of an expert and later on facing them at trial, if they're a medical expert and they're relying on these 4 or 5 articles, you want to try to find articles that are contrary to what they're relying on, and ask them, aren't these good articles too? Why aren't you relying on them? Or similarly, there are these other experts out there. Do you know Dr. So-and-so? He says something different. Why don't you agree with him? Why do you think your position is better? Those are things that you're probably going to flesh out at the deposition, and then you're either going to make more of a deal of them at trial, or you're going to know how to prepare your own experts at trial to deal with whatever they say.
Isn't it true, like, sometimes the expert has a degree in something totally unrelated, and their expertise is, like, later developed based on later work or reading
Yeah, I mean, that's more.
Like someone could be a general doctor, then they later do research or reading these articles and become an expert that way, or is that not?
Yeah, and that might be a situation where I challenge the expert later, either via motion in limine or a request for, and we'll discuss this more in one of our trial sessions, or a request for a 402 hearing, where you have like a mini trial on the expert's qualifications and whether they're, they have the background qualifications to say X, Y, and Z. But certainly that's, something you want to probe at the deposition, because that's going to lay the foundation for your limine motion or your request for 402 hearing later on when you actually get to trial. So, anyone else? Cool. Dorian?
With the criminal section of the event. The criminal section we're talking about is pretrial investigation, sort of marshaling the facts, figuring out, getting the information you need to defend your client. So let's start with the first step. So you got a criminal case from the conference panel. You go to court, and you meet your client. Maybe you get a police report and a complaint, and you look at it, maybe glance over it, and the question is, where do you go from there? And the answer is, you want the best source of information about what happened, about the underlying incident, is your client. Now, I say best source. That probably isn't exactly true, because I've noticed that until you build some trust, build a little bit of relationship, your clients sometimes like to understate their role in whatever got them into the situation that they're in, that they have to be referred to from the conference panel. But at the very least, what's in their head. Sometimes when I meet people, I just say, "Why are you in here?" And they'll just say, "Oh yeah, I got arrested for fighting, or I beat this guy up, or I stole something." And then you kind of know where their frame of mind is and which way to start going. In the notes, I put just a couple of things you probably want to ask your client about. Ask them their name, phone number, address, background, citizenship. That's a big one. Ask your clients about their citizenship, because convictions of certain crimes have immigration consequences that are sometimes much more severe than the consequences of the crime itself. So make sure you ask that.
I have a note too, just quickly. Also, if you get a conflicts case and there is an immigration issue, you can get a immigration specialist through conflicts. So that's also very important.
Yeah, that's true. Those folks know what crimes get you deported versus which crimes don't, and that can be really, really important in negotiations as well as disposition. Ask about prior arrests, prior convictions. Ask about warrants, ask about probation, ask about parole. It sounds silly, but sometimes I've had cases where I get a guy, he goes, "Yeah, I was arrested for resisting arrest. You got any criminal history? No. On probation? No." So on and so forth. I actually had a case, and then eve of trial, I get a police report from the DA. Guy was arrested for 148 10 years ago under factual circumstances that were very similar to my case. By the way, 148 is resisting arrest, if I didn't already say it. And let's just say that hurt my case a lot. And I asked my client, I said, "Why didn't you tell me about this arrest? Like, you didn't think the DA was going to find that out?" He was like, "Well, no, I wasn't arrested. They just, gave me a ticket." Well, I read the police report. Sure enough, that's true. But in California, a ticket counts as an arrest, that you're essentially signing a promise to appear as opposed to being taken into custody. So it's important that you ask people about their background, and I've noticed sometimes people even forget, so you may even want to do your own check. Usually in this county, the DA will give you the police reports, they'll give you the rap sheet. That's about it. You usually have to ask for everything else, and be sure to ask for those things. The other thing I do is I often have clients sign a HIPAA form, and I often have them fill out a fee waiver. We're going to talk about, we'll talk about the HIPAA form now. HIPAA form is just a release for medical records. That could be really important in cases where maybe your client has some mental issues, or where maybe drug issues, or maybe they're trying to qualify for a drug program. And none of these drug programs will even talk to you until your client has a release for you to get them treatment and things like that. So just have it. It's really unfortunate when the client goes to jail and you're trying to get them in a program and they've got a bed that might be available for like an hour, and then you have to go to West County to get your client to sign a HIPAA form because you didn't do it right away. So just do it, and it'll often come in handy. We'll come back to the fee waivers a little bit later. Let's talk a little bit about discovery. Actually, before we talk about discovery, let's talk about, I'm going to add a little section to my outline, 1.5. So you got the police reports, you've talked to your client. You know, one of the things about criminal work is that oftentimes we don't have investigators, at least the same ones that they have, the DA has, and we have to be a little bit more ingenious. Sometimes we have to do a lot of the work that the police would do if we were on the other side of things. When you get the police reports, use them. And when I say use them, go to the location, call the witnesses, call the LPO who saw your guy steal. A lot of times people go, well, I don't really want to call them. They're just going to say what they said in the police report. Well, you know what? The police report often just cuts to the chase. They leave out the 20 minutes of them saying, you know, I ducked through the store, I hid behind this thing, he went that way, these other guys ran, and they go, you know, so-and-so was seen shoplifting and he confessed to the theft. Well, call the LPO or call that witness, because sometimes they'll tell you a lot more than what is in the police report. You know, one of the reasons you want to do these pretrial investigations, because if there's one reason criminal attorneys sometimes get in trouble, it's because of inadequate investigation of their cases. They get the police reports, they go, man, my guy has no case. They don't even think to call the witnesses. And often you learn things that are important. I'll give one example of that, and then we'll move on. Had a guy who was accused of burglarizing an apartment building. Statement from a security guard. There was a witness, apartment manager, called the apartment manager up, said, hey, tell me about this guy burglaring your apartment. He goes, oh, no, he wasn't committing a burglary. He's a homeless guy who just hangs out here all the time. And sure enough, he was a homeless guy who just hung out there all the time. And didn't really help my client because he wasn't supposed to be at that building for other reasons, like a restraining order. But you know, even though he got in trouble, it wasn't what the police said it was. And I learned just by calling this guy. And average people who are witnesses aren't necessarily trying to can your guys, but the police often cut to the chase and leave out the parts that might be exculpatory. So do that. All right, let's talk about discovery. Let's talk about the law. You have two rights, or two sources of rights of discovery, mostly in California. The first is constitutional, the second is statutory. Let's talk about the constitutional one first. Who here has heard of Brady versus Maryland? Is that everyone? Okay. So Brady talks about information you're entitled to receive from the DA. And in particular, you're entitled to receive any information that's exculpatory. And exculpatory being any information that either helps the defense case or hurts the DA case. Now, truth be told, Brady's pretty complicated. There are 500 to 1,000 page books written about just Brady. I have one of them in my office. But the short story is the DA has to give you any information that would help your case or harm their case. And that's, that can be broad. One of the areas that people don't realize is that if they're going to call a witness and there's impeachment on that witness, they have to turn it over. If they are calling an expert that's been found uncredible in the past, they have to turn that over. The one bad thing about Brady is that if your client gets convicted and then it later comes out that there was a Brady violation, there was some exculpatory evidence, the courts are going to look to see whether it was, quote, material. And the material bar is somewhat high, particularly on appeal. The answer is, would having that impeachment information, having that Brady information would have changed the outcome of the case? Or has a reasonable possibility of changing the outcome? If the answer is yes, well, you may be able to get a reversal. If the answer is no, too bad, even though there may have been a Brady violation. And I think you guys can certainly sympathize with the idea that things that we think were very material, sometimes the DAs and the courts tend to give short shrift to. So that's the bad side about Brady. There's a little bit of a high bar, particularly on appeal. It does apply to preliminary hearings, and the corresponding burden of proof applies. So in other words, if there's a reasonable chance that testimony or impeachment would have changed the outcome of the preliminary hearing has to be turned over pursuant to Brady. Let's talk about your statutory right to discovery. So Brady, of course, is the law of the land. Every state has to follow Brady. But California actually has its own statute. That's Penal Code 1054. And there are different sections that talk about the information that the defense has to turn over to the prosecution and the stuff the prosecution has to turn over to the defense. Now, in my outline, I've listed all of the things that the prosecution, by statute, has to turn over to the defense. You can read them, just names, addresses of witnesses, written statements, any felony conviction of a material witness. There's a few other things. You can look at the list. The key thing about statutory discovery is that it doesn't quite mesh with Brady perfectly. There are things that the DA have to turn over by statute that Brady may not require them to turn over, and vice versa. There are things that Brady might require the DA to turn over that the statute might not. And it's important to realize those distinctions, particularly if you bring a discovery motion, because you want to know what the source of your motion is, right? You want to know, am I bringing this based on the statute, or am I bringing this based on Brady, or both?
Question.
Uh-huh.
On the disclosure of convictions,
Yes.
is the DA required to only disclose convictions that they know about, or are they required to look it up for every, so let's say they've got a witness and they say, I don't even care about his rap sheet, I'm not going to look into it.
Right.
So they don't know if anything exists, you don't know. Do they have, if you ask, or even if you don't ask, do they have a duty to run the rap sheet of that witness and find out if they have any convictions?
The answer is yes. Now, I'm going to be a little bit picky here. Obviously, for Brady purposes, that witness has to be material, right? So if that's the 10th witness that saw the same thing that 9 other people saw, and this 10th person had the worst view of all of them, and then it turned out he had some felony, it's not going to get you anywhere. But if this case rested on that witness's testimony, and they turned out to have some impeachment information that was not turned over, the DA would have a Brady problem. The DA does have a duty to run rap sheets, and they have a duty to search their files. And anything that's in a DOJ database or in law enforcement hands is they're considered to be in constructive possession of. So yes, the answer is yes. That does not mean that you shouldn't go look yourself, particularly here in Contra Costa. You should probably go to the clerk's office and give them some names and dates of births and say, hey, even for your own client, you should ask them because you may find out things that the DA missed. But they do have a duty to turn it over. There's been a bit of litigation about police officers and rap sheets. We talked about pitches last time. If you want to find out during a police officer, I know this public defender's office have been pushing for the DA to have to run rap sheets on police officers. The courts, for the most part, have not required them to do that. And I recently saw case law, actually this year, where the court said the DA does not have to run rap sheets on police officers, but if they choose not to, and then something comes out in the future that was Brady, it's on the DA, right? But they don't want the courts telling the DA how to go about meeting their Brady obligations. So that's statutory. I pointed out 2 examples of the notes that I just want to point out. The statute requires all exculpatory information to be turned over. Brady, material. The statute only requires felony conviction to be turned over. Brady, all convictions, or even impeachment, or even dishonest acts, or felony or misdemeanor acts that did not result in a conviction have to be turned over. So that's what I mean when I say that they don't quite mesh. You got 2 different sources, and so just be aware of that. If the DA does not turn over the discovery that you want or request or think that you're entitled to, you got to follow discovery motion. Sometimes we get cases, clients in custody, it's set for trial within 30 days. You got to go get an order shortening time. You got to get that thing on calendar. If you don't follow the discovery motion, and then it goes to trial, and then there's discovery later, the court's going to go, well, you never asked for it. Too bad. All right? But if you follow the discovery motion, you're making a record to where if something ever came out in the future, that could potentially undermine the conviction.
It might also be malpractice if you don't file an informal discovery.
I think that's probably true. You probably, at the very least, want to ask the DA for the things required by statute and for Brady evidence. I think that's true. The DA has an obligation to turn over Brady evidence regardless of whether you make a request or not. However, I don't believe the same requirement applies to the statutory things that they're supposed to turn over. Has anyone ever seen a informal discovery request?
No.
Okay. Well, the answer is just write a letter asking for the things in the statute, and if you want, you can almost cut and paste the statute in your letter. I also recommend at the bottom of your letter putting in specific items that you are interested in, because the DAs don't have time to just whiff through the entire file. They should, but they don't, realistically. And so if you want the 911 call, and that's really what you want, ask for all the stuff, and then at the very bottom say, and by the way, give me the 911 call, and the dispatch log, and digital photos, and that way they have a little checklist that they can get you the stuff a little quicker. Got a question back?
How many chances do you give the DA on an informal discovery request before you go with a motion?
That depends on the time. If it's a time waived case, and we've got all the time in the world, I would probably file a second one. I'd ask for the stuff, and they didn't give it to me in about 2 to 4 weeks. I'd probably file a second one. If they didn't give it to me after that, I'd file a motion. If you're talking time not waived trial, where you are about to try your case in 3 weeks from the first time you appeared, you file your informal discovery request. Don't give you the stuff in a week or two. You've got to file the discovery motion right away with the order shortening time. And they're probably going to make you do the motion in the trial court, but you want to try to get the motion on as soon as you can. So give them a chance, and they should be getting that information to prepare for trial. And if they don't, great, because they'll have no evidence against your client, right? Yeah, you hope. Okay. Does anyone have any questions about that? Otherwise, I'm going to move on pretty quickly.
Yeah, I want to ask, going back to talking to witnesses.
Sure.
We don't get depositions.
Right.
So what do you do if you call up a witness and he just says, oh, I don't want to talk to you?
Okay. Sorry to all the kids watching when I use the F word. Here's the deal. You call up the witnesses, and sometimes they're not going to talk to you. It's really weird, to be honest with you, that civil, when we have these disputes about money, you have all this discovery, right? It's this real truth finding, right? But when it's criminal stuff, we don't want discovery because, people can only end up in jail for the rest of their life or dead or whatever the case may be. It's really absurd. But the real reason I think that is a problem is because they really don't want people to see how law enforcement operates, right? Law enforcement is the secret entity, and if there was this true cross-discovery, they'd have to cough up a lot more information than they're required to. The answer is you still want to make the call, because what's going to happen is you'll call someone, and so most people will actually talk to you. I know it's shocking, but my experience has been pretty positive. But there are going to be people who don't want to talk to you, and the worst thing they're going to do is say, like, fuck you, and hang up on you. That's the worst thing. And if they do that, you get to call them to the stand and go, isn't it true when I called you to ask your side of the story, you said fuck you and hung up on me? And it undermines them, right? So just make the call, and then if they really are a jerk to you or they treat you unfairly, use it as impeachment at trial or at prelim, because you can't do that. If they say no, you're kind of screwed because you can't be a witness in your own case. But most people won't deny it once you ask, and frankly, you can't ask unless you have a good faith basis for believing they did that, so you would only ask if they did that.
So how often do you piggyback onto that? How often do you use an investigator to talk to witnesses instead of doing it yourself because of that problem of you can't be a witness in your own case?
I do an investigator in cases where I think it will matter. So, for instance, if I'm talking about a shoplifting case and there's an LPO who made a statement in the police report that my guy stole a bunch of stuff, I'm probably not going to use an investigator because I'm going to call them up. There's a very negligible possibility that they're going to go, but your guy actually didn't steal the stuff, right? No one's really going to say that. They're just going to say he stole the stuff, but here's some additional information. There's not really a big risk. When you're talking about witnesses who maybe have recanted, maybe have said different things at different times to different people, or if you believe a witness is going to be hostile towards you, maybe because of previous interactions or because it, maybe their beliefs about the system. If you just kind of have to feel it out, and it takes a little bit of intuition. But those are the situations where I would use an investigator. Conflicts provides them. You just have to write up the little one-page thing explaining why you need an investigator. that's specific to your case, and you can get one. So I recommend that. Some people only use investigators. Some people never use investigators. I kind of fall in the middle of that, but I recommend talking to people about their different styles.
Sometimes too, I'm kind of like you, like it depends. And, I also sometimes have an investigator, and then sometimes the witness will call me anyways. Right. You know, so and they feel more comfortable talking to me. Maybe I don't. You know, or sometimes I try calling the witness, and they don't want to talk to me, and they feel more comfortable talking to my investigator. So it just really depends on a case by case situation.
When you use an investigator, such as through the conflicts panel, do you tend to go with the investigator to interview witnesses, or do you just let the investigator do it on his or herself?
I typically don't. Other people I've heard sometimes do it differently. The reason I don't is because I feel weird about like double billing the conflicts panel for like going to do something like that. And on top of that, I feel like it eliminates one of the main reasons you get an investigator, such that you're not a witness. And if you're there, I guess you're not the only witness, but you are still kind of a witness, right? So since I'm only going to get an investigator on cases where I expect a witness to be kind of like shaky or questionable, I typically will remove myself. If I'm interviewing a witness where I have no concerns about that, it'll just be me because I don't have any concerns. That's a good question.
I agree with that too. And I have another note is that I only try to go with them if there's something that we're doing together. Let's say there's some sort of video that you want to look with your investigator. Let's say your investigator's already interviewed this witness and this is like a secondary thing. You want to look at a video together and the investigators interviewed them, or you want to get a statement from this witness and they may be hostile, but you need to be there because you're the attorney and you know how to lay out the statement, how you want it. You know, so you just kind of have to understand. But if it's just to go interview a witness, I would usually just let my investigator do their thing. You know?
Yeah.
One thing, it seems like you're saying that whether you ask witness or not, or investigate, it seems like it's a sort of like, well, you know, it's, you should do it for your case. But suppose you're lazy. Is there a degree of professional responsibility you actually have for due diligence you have to call? You know, if you don't call enough, they say, hey, you basically screw up your case.
I think the answer is yes. I mean, in the sense that I think if there's any witness who's the linchpin against your client, you need to be calling that witness, right? So I guess think about sort of the materiality standard. If there's, you know, do you need to call every single witness? No, not necessarily. If there's and it's circumstantial, right? So if you have 2 eyewitnesses to a severe crime, should you interview both of them? Probably. If your guy's caught on video committing that same crime, do you need to do the same level of interviews that you might have if it wasn't on video? Probably not. So there's some give and take. You might still want to talk to the people, but I guess it's somewhat of a balancing act. Limited time, limited resources. Kind of have to figure it out. But in absence of all confession or video, I would try to talk to what I would consider the material witnesses in just about every case. All right. Any more questions about discovery? I thought I saw your hand up earlier.
It was kind of a related question. I've had other people like recommend the buddy system, like take somebody with you if you can't afford an investigator. Like in counties where you have to ask the court's permission for funds for an investigator. And I know that from being like in PD's offices, they have investigators and then they have law clerks.
Right.
So you know, it was always the law clerk like, come here and listen to this so I can call you to testify on behalf of me. Like, do you just like pick anybody, or are you just not a fan of like the buddy system?
No, that's actually a great system. You guys all know that my background is a DA background. It was not uncommon for me to get like a domestic violence victim and say, hey, you, are you busy? Come to my office. And I'd interview that person, knowing that person might recant, maybe. You know, so no, that's a great system. The buddy system works. You know, it works in a pinch. In a perfect world, you'll have an investigator, so you're not using up attorney time. But that's a great system. I like it. I recommend it. And if you have a good friend, take them with you. If you would need to take pictures or do something where you want to witness, do it. Absolutely, great suggestion.
Or you feel scared. Maybe you're scared.
Yeah. Okay, any questions about investigation or discovery? All right, we're going to go to the last section. and that's records. First of all, a lot of things that we do in criminal law, a lot of people don't even tend to think of records, but they're really, really important. Number one, when you first get a complaint, if there are priors alleged, you should be getting those records. Sometimes the records that you want are sometimes like medical records. Sometimes you want to know your client's mental history, you want those records, right? And, part of our cultural, I think a cultural value we have here is that things on paper, for whatever reason, are given more credence than oral things, right? It's like, you hear someone speak, that's one thing, but someone publishes a book, and it's like super impressive, right? It's given more credence in our society. But the point I'm trying to make is that records can be really, really important. Number one, California has a very liberal California Public Records Act. So use that. All you have to do is just write a letter saying, I'm requesting this under the California Public Records Act, and they got to give it to you. And if they don't have to give it to you, they'll tell you why. And look it up. There's only so many exceptions, and they've got to say exactly what the exception is. And if they're wrong, and then you do a petition in court to have to get these records, they have to pay you. They have to give you the records and they have to pay you for everything that you did to go get it. So, in general, if you cite something saying that you should have these records, they will give them to you because people don't want to be wrong. They don't want to pay all your attorney's fees to get, $1 worth of public records. So, it's a very powerful thing. Most law enforcement records, unfortunately, are exempt from the California Public Records Act. However, the statute specifically includes a bunch of stuff, and I listed those things here in my outline. They got to give you the full name and just occupation of anyone arrested, description, date of birth, arrest, location, factual circumstances. So it's interesting. Police reports are exempt, but they pretty much have to give you all the information that's in the police report. So if you do a public records request and you're trying to get information about maybe a previous arrest, first ask the DA. They may be able to get it for you, and they may provide it. But if the DA is balking, use this language from the statute that says the things that are not exempted. And they may just give you the report because they don't want to spend all their time redacting and doing all that stuff. Even if something's not a public record, they usually have the ability to give you the record anyway. That is, they're not barred. It's just permissive as opposed to required. Go ahead.
Does this include booking photos as something you can get?
Booking photos? Yes. Booking photos are a public record, and that's
you
one way.
request that directly from the police department?
You can get that directly from the police department.
Do you
Now,
want to go through the DA or direct through the police department?
well, you can go through the DA, and the benefit of going through the DA is when you go through the DA, you have all of the rights that are given to you by statute through reciprocal discovery. When you go straight to the police department, you are not doing it sort of as discovery. You're doing it kind of as you would as a member of the public asking for a record, right? So you're not really giving more credence because you're defending someone who they arrested, but any member of the public is entitled to the information that is listed in my outline, excluded from the exemption of the Public Records Act. So I guess is the public record, right? Rap sheets are not public records, but you can always get your clients from DOJ. In this county, the DA will usually just give them to you, so don't have to really worry about that. DMV records. A lot of the DMV records are exempt, particularly people's home address, stuff like that. But you can get convictions, abstract of convictions. You can get suspension, revocation information, things like that. The other type of public records are court records. Now, court records are interesting. They are not covered by the California Public Records Act, and that's obscene to me. But there's very strong case law, which have pretty much said they're all public, and you have access to them. So people most people don't even know how many records they actually have access to. And when I say that, any minute order, any motion filed, you can access the public record. Warrants, the affidavit supporting the warrant, right? All that's public record, right? People don't even think to ask for this stuff, but if your guy gets the door kicked down, you can get that stuff. Probation conditions, right? Your client gets a probation search because this third party was on probation. Go get their terms of probation. It's all public, all public. Juvenile records are excluded. There are a couple other minor exclusions, but the point I'm trying to make is that almost any record generated by the court system is public. It's huge, and it's a huge source of information. All right, so don't overlook it. Probation reports, those are public too, until 60 days after the case ends. And at that point, they become private. You have to petition for them. And even then, you're presumed to have access to them unless the person who is on probation objects. And even then, they have to have really good reasons. So you can get all this information. There's a lot of information out there in the court records. The last topic I'm going to cover, because I know time is short, everyone wants to go home, subpoenas. Everyone knows that if you want a witness to come to court, you should subpoena them. It's really important, even if they're a friendly witness, because if they get hit by a car on the way to court, you want to have good cause for a continuance, and if you didn't serve them, you don't have good cause. All right? So serve your friendly witnesses, and of course serve your hostile witnesses, because they won't come if you don't serve them. But the other type of subpoena is a subpoena ducis tecum. It's a very important tool, and one that's underused. The reason it's underused is because you can have any third party in the world bring any records to court for any court appearance as long as it's relevant to your case. Think about that for a minute. So any hospital records, you can subpoena public records, you can subpoena Facebook records, you can subpoena phone records, you can subpoena all these things. Now, there are some exclusions. Federal law protects the content of some electronic communications. There are some exceptions to the general rule. But the world is vast. You can subpoena a credit card. You can subpoena a whole world of information. And it's very, very powerful if used right. The other thing that's really powerful about subpoenaing this information is that due to what I call subpoena magic, not only do you get these records, but they become admissible, assuming the person who gets the subpoena fills out the paperwork right. Because you send a subpoena, they do a business records declaration, it all gets sent to the court opens the envelope, you get the records, they're admissible, assuming what they wrote meets the business records exception. That's a great way to get in medical records, psychiatry records, without having to pay a doctor $5,000 to come to court. All right? So use the subpoena ducis tecum. I'm just going to cover one last thing. And in my documents, you see I put a subpoena. That's an example of a subpoena ducis tecum. If you see the form labeled CR-125, this is a typical subpoena for medical records. So use the form. The last paper I have in here is the request for fee waiver. That's an odd addition because, as you know, if you're representing someone who's indigent, they don't really have to pay too many fees. They get a free lawyer, etc. The reason I have that in there is because if you have the clerk's office do a fee waiver and you have a judge waive your client's fees, the sheriff will serve everything for you. And if the sheriff will serve anything for you, that means that you can serve subpoena ducis tecums or any witnesses through the sheriff. And that's kind of important. Well, not important, but it's great because you don't need a private investigator. They're required to serve it. They know how to serve it. They can serve it at any hours of the night. And I have to say, there's something cool about using law enforcement to help bolster the defense of a criminal case, don't you think? Yeah, there's something really cool about that. So I have to rush through that last part. If anyone has any questions, I'll answer them. Otherwise, I'll shut up and everyone can go home. All right, I'm shutting up. Thank you for your time and attention. Please take the Chinese food.